Welcome to another episode, everyone. Let's watch as the judge sets a $5 million bond for these young individuals here, which means they are not going home anytime soon. The charges? Worthy, according to the system, of a $5 million bond. The charges are grisly and gruesome, about to be read in open court. Like and subscribe, please. Don't cry now. I'm looking at tears being held back on everyone's face. Don't cry now, particularly when you hear the charges. Do not cry now. All of you individuals, you young dudes, you YNs need to cry now, not then. Start crying now. Change your ways now. Once you're in there, you have on this orange jumpsuit, you're cuffed up, being escorted into the courtroom by non-filling individuals with a non-filling judge who's just there, no knock on the judge, he's there to administer the law, not to insert her personal feelings. And that's exactly what they do oftentimes. Once you find yourself in this position, it's too late to start crying. It's too late to close your eyes and start praying. Do that before you find yourself in this position.
All rise. Court is now in session. I'm Sherry Madej presiding.
Please be seated. Good morning, everyone.
I feel bad for him. Any one of these young individuals can be my son or what have you. Looking at the age of them or whatever, you know. Hell, probably even my damn grandson. So I'm not making light of it, and I don't want to come down too hard on these individuals. They're young and obviously was misled and misguided somewhere down the line, clearly. Someone did not do their job with guiding and directing these young individuals to the right way of life. That's just the bottom line. Not to absolve them of guilt or whatever they did, which we're about to hear, at least some of them or whatever. I mean, no one made them do this. But a $5 million bond is diabolical. And unless Puff Daddy, P. Diddy is their daddy, they're not going anywhere. They don't have $5 million. Pretty nervous. Looking nervous as hell.
Ladies and gentlemen, this morning it is my duty to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the Constitution of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by a jury, or you can...
Look at him. Look at that face. That's the face of fear, of, uncertainty of what's to come with his life. That's the face of, I done messed up now, probably for the rest of my life. That's the face of, I wish I can take it all back. That's also the face of a very young man. Don't let the sideburns fool you. Look at his face. How old is this individual? 16? 15? 17, maybe, I don't know, 18. He can't be older than 18. But he's about to get hit upside the head with a $5 million bond, which means the charges are very bad. You get hit with a $5 million bail, you can have a murder and get a $200,000 bail, $100,000 bail or something. $5 million? No way. In other words, the judge is letting them know you're not going anywhere. Whatever the charges are, perhaps I cannot give you no bail. You have a right to have bail, so I'm going to give you bail. I have to give it to you. So states the law. Nevertheless, I'm going to make it to where you cannot make this bail, where you cannot get out. There's no way.
Give up that right and have your case tried directly by a judge without a jury. At trial, the state of Ohio has the burden of proving your guilt by evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to...
Ohio, boy, they've been acting up out there in Ohio a little bit. I did a few stories in Ohio lately. They out there turned up. Ohio? Boy, you never know where it's going up at.
Cross-examine witnesses for the prosecution. You also have the right to summon or subpoena witnesses on your own behalf. You do not have to testify against yourself. You have the right to counsel. If you're unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you're unable to pay this fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have a right to a reasonable continuance to hire one. You are not here for the trial of your case this morning. You are here for your arraignment.
Quick pause. This is a critical moment. An arraignment is not a trial. This is where the court formally tells defendants what they're charged with, sets bond, and asks for a plea. No evidence argued yet, but every word here matters. Would you waive your rights this fast or ask for more time?
Arraignment is your opportunity to be informed of the charges against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made by you can be used against you. As your name is called, please step forward. You will be asked when you received a copy of your indictment or information and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going forward by way of information, I will ask your attorney to place on the record that they discussed with you waiving presentment of your case to the grand jury. You will be asked 4 questions. If you understand the charges against you, if you knowingly and willingly signed the waiver, if you consent that charges proceed by information instead of indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice and the reading of the information. You will be asked how you plead. A defendant may plead not guilty by reason of insanity, or with the consent of court, no contest. If you want to plead guilty and you do not have an attorney, the court will assign counsel for you so that you may have a full understanding of your constitutional rights. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with the crime of violence and/or drug offense, under Ohio law, you cannot knowingly have, carry, or use a gun, a firearm, or a dangerous weapon until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges you are being arraigned for today. Even if you have a CCW permit, you are still under a disability until your case is over. In fact, upon indictment, the sheriff who issued the permit shall suspend it until your case is over. Finally, If you are over 18 and you have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. Inmates in the county jail have the right to be present in the courtroom. Mr. Corrigan, do you have anyone in the jail that wishes to be in the courtroom this morning?
Two men, Your Honor. Mr. Daquan Martin and Rodney.
Well, that one down there at the end, not him, the one down there towards the wall, he looks real, he looks shook up. He looks real nervous. The one right there in the middle, too, though. All of them, man. They all look like they've been crying. Look at their eyes, watery and red and all this. This is not a joke. They realize that now. And you all better realize that now. That this is not a game.
Cuthbertson. We're going to send them over tomorrow.
Okay, thank you, Mr. Corrigan. We're ready for
You're
our
welcome.
first case.
We'll start in courtroom, case number 630080, co-defendant A, Devontae Nettles.
Big dude, that dude with the braids, big old dude, big old young. Here we go. Man
Morning,
down,
Mr. Nettles. How are you today, sir?
man
Good.
down.
Do you have an attorney?
No,
Do you have the money to hire one?
I'm going to get myself.
Okay, tell me who you're going to hire. Do you know? Okay. All right, the court will appoint 2 attorneys because of the nature of this case to represent you, all right? Have you received a copy of your indictment? And when did you receive it?
The court, well, let's pay attention now. This is serious. The court will appoint, listen to the judge, listen to what's going on in here. This is your life. And this will be you all's life. If you're not careful, you want to keep running the street thinking you're tough. You young YNs, or you old individuals who haven't matured yet. The judge just said, I'm going to appoint you 2 lawyers because of the nature of this case. 2 attorneys. It's going to be so much work that one person can't do it. Well, these are some serious charges. Whenever the court appoints you 2 attorneys to deal with the charges, very serious stuff. This is not to mention the investigators and the like, which the court is also going to appoint or pay for.
Yesterday,
Yesterday? Has it been 24 hours?
probably.
Okay. All right. Do you understand the charges against you? Do you wish to waive the 24-hour notice so that we can proceed today? Okay. Do you wish to waive the reading of the indictment in open court? You have the right to have me read you the entire indictment in open court. Do you want me to read it to you? Okay, so you waive that?
$1 million. That's the court signaling how serious this case is. Cash, surety, or property. Either way, this bond effectively keeps the defendant behind bars. Judges use bond not as punishment, but as protection for the community. Do you think bond should ever be this high?
Okay. By waiving it, it means you're giving that up. Okay. Do you wish to enter a not guilty plea today? Okay, sir, I accept your not guilty plea. The court will appoint attorneys Fernando Mack and Rufus Sims to represent you in this case. Your bond is set at $5 million. That's a cash surety property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. Your first pretrial will be on July 11th at 9 a.m. Okay? Good luck.
Whoa, $5 million, bro. So he chose not to have the indictment read in open court. I'm curious, what went on here? What happened? Why would the judge set a bond at $5 million for this young individual? Not that age has anything to do with it. I only say that it factors in because the crime must be a grisly one. Even at this age, for the judge to set the bond at $5 million. Again, I've seen individuals responsible for gruesome crimes get less than $1 million bond, in many cases, $100,000, $200,000 bond. So $5 million. Again, unless your father is P. Diddy or Jay-Z, you're in trouble. Tom Brady or somebody, you're in trouble. Unless your godmother is Oprah. They ain't got $5 million. That's why he's sitting there looking solemn and sad. So he chose not to have the indictment read in open court. I'm curious what's going on, but I did see a little bit. I didn't see all of this, but I saw a little bit more up to the next person. And he, in fact, let her read the indictment in open court.
Andrews. Co-defendant B. Montez Andrews.
This is a big dude. Look at it. He towering over the guards. They don't look like they some short or small individuals. This is a big youngster right here. Look at it. Look at his build and everything. This is a big dude. Going to fill out, going to be huge. Be on that football field or be a scientist. Be an entrepreneur. Be a brilliant mind for our community. Anything but be in this position because we need you out here fighting the good fight. You're not fighting the good fight if you're locked up. You're not doing black women any good, black women any justice. You're not helping to propagate and continue the race by planting your seed in the black woman because you're locked up. And you're not doing the community any good as a whole. And if you're in there for a crime against someone in the community, then you certainly did not do the community any good whatsoever. But again, who is teaching these individuals? Who is guiding and directing these kids? Big individual here could have been anything. Now, I don't know that his life is over. And I don't mean to speak about him in the past tense. Perhaps he can overcome this situation. Perhaps it is not insurmountable, whatever the situation is, when we're about to hear some of it. But they appear to be steep involved in some trouble when the judge sets a $5 million bond.
Mr. Andrews, how are you this morning? That's not you? Are you Mr. George? Okay. Can we do Mr. George? Okay.
Set for the co-defendant C. Aaron George.
Mr. George, do you have an attorney, sir?
No, my dad about to give me a lawyer.
Okay, do you know who your dad's going to get you?
No.
You don't know his name? Do you know if your dad has paid anyone yet? He has paid him?
Like he put the house up for that.
He put his house up? Could that have been for your bond?
No, for my lawyer.
Okay. All right.
How's it going to be for a bond? And it looks like you're about to set his bond now. Did he already have a bond? Apparently. Because the judge just asked him, for those who may not have heard it, not to belabor the point or to reiterate it, but the judge just asked, do you have an attorney? And he said, no, but my father is going to get me an attorney. And the judge said, what's the attorney's name? He doesn't know the attorney's name. And so the judge said, well, has he paid for the attorney? And then the young man here by the name of George, I believe perhaps his last name, said that his father put up the house for his attorney, put up the house, put up his home for his attorney. She said, well, you sure it wasn't for bond? He said, no, it's for an attorney. Yeah, because especially if you're about to give him a $5 million bond, again, unless his daddy is Puff Daddy, unless he's living in a mansion, then putting up a home for a $5 million bond will not suffice unless the home is worth $5 million. I mean, how many homes are worth that? These individuals are in a big pickle. So his father may have put up the home to get him an attorney. You know, this is a very young man. His father wants to save his life. His father believes in him, and this is his child, and is willing to put up his home. You know, things go wrong, then he loses his home. So you have to think before you act, because you put not only yourself in a bad predicament, but your loved ones in a bad predicament whenever you act out an ill decision. Whenever you act it out, it's not just you that suffers.
Do you know if your lawyer was supposed to be here this morning?
No.
You don't know? Okay. All right, Mr. George. Have you received a copy of your indictment?
Yes.
Do you understand the charges against you?
Yes.
When did you receive it?
Yesterday.
Yesterday? Has it been longer than 24 hours?
No.
No? Okay. Do you wish to waive the 24-hour notice so that we can proceed today?
Yes.
Okay. Do you wish to waive the reading of the indictment in open court this morning? Do you know what that means?
No.
Okay. So you have the right to have me read the entire indictment.
Can't really come down too hard on him for not knowing what that means. How old is he? Very young man, but still, I'm going to make the point anyway that you're out here committing crimes, and I don't know that he committed a crime. We'll see. He's in court. This, again, is the arraignment, not trial. He hasn't been found guilty of anything. I certainly hope this young man is innocent of the indictment that she's about to read out. But my point was just going to be that he doesn't even know what she just said. You're out here committing crimes and don't know the law and don't understand what she just said in simple terms, which is you have a right for me not to read the indictment out in open court today. Do you wish to waive that right? I don't know what that means, Your Honor. Why are you in here then, man? Should be at home at school, practicing, studying. Someone should have been guiding him to do just that. We all failed these people.
To you in open court. You want me to read it to you? Okay. Thank you. Okay. This is the matter of the state of Ohio. How do you pronounce your first name?
Aaron.
Oh, okay, you're not Mr. Andrews. Aaron George. The state of Ohio versus Aaron George. Case number 630080. Dates of offense, June 20th, 2018. Count 1, aggravated murder. This is an unclassified felony in violation of 2903.01C. The jurors of the grand jury of the state of Ohio within and
Doesn't sound too bad. Well, I mean, it's bad, obviously, but what did she say? Aggravated murder? You know, doesn't justify a $5 million bond. She, of course, hasn't given him that yet. She gave the first individual a $5 million bond. I'm assuming she's going to do the same here. Looks like they're all co-defendants. And so, you know, you may say, well, damn, he clickbaited talking about a grisly, gruesome crime. This is just aggravated murder. You know, people are murdered every day, unfortunately, in this violent, hypocritical country. But it's not just that, it's who he is alleged to have murdered. Let's continue.
for the county aforesaid on their oaths in the name of and by the authority of the state of Ohio, do find and present that the above-named defendants, on or about the date of the offense set forth in the county of Cuyahoga, unlawfully did purposely cause the death of S.N. 2/6/2009, who was under the age of 13 years of age at the time of the commission of the offense, to wit, February 6, 2009. There are 3 firearm specifications on count 1. The first is a 1-year firearm specification pursuant to 20.
So that's the problem, is that they have all of these firearm specifications. So apparently it was done with a firearm, but this child was under the age of 13. That was unalive, that was brutally killed, that was deleted under the age of 13. These crimes do not go over well in prison because this is still a child. You're going to have to answer to this. If you're found guilty, you better hope that you're not found guilty of this. Now, apparently, all of these individuals, or whoever, I don't know if all three, perhaps we'll find out before the video is over, if all three are accused of this same thing that were just sitting in there. And the first one that she gave the $5 million bond to, I believe that they're all connected. It looks like it. She mistook him for the other dude at first, and he was about to leave. She said, no, I'll just do you now. Looks like they're crimees. They're partners in crime. And they all are very young. So though the individual who they are accused of deleting have not been found guilty of, again, yet, we'll see what happens. But all three of these individuals were young as well. So we say, oh, he was 13 years old. And that was my first reaction, man, this was gruesome. A 13-year-old who was apparently, again, viciously unalive. But, you know, how old were these individuals when the crime was committed? They all seem rather young themselves, all of them. And if the crime happened, well, it probably didn't happen a long time ago because they're just now being arraigned. They're being arraigned now. The trial may take a while, but they're having their arraignment now, which means typically that they just got locked up for it. Whenever this arraignment, whenever this video took place, I don't know, but they had just got locked up for it. So whatever age they are now, you know, a few days prior. So whatever age they are now is pretty much the age they were when the crime was committed, if it was committed by these individuals, allegedly by these individuals. So when we're looking at it, I thought maybe someone below the age of 18 and the individual that's sitting there now, they all look about that same age though. So the dude was 13, or the individual, the kid was 13, who was deleted, unalive. Unfortunately, rest in peace to him. These individuals are also young, perhaps teenagers under the age of 18, all of them.
941.14A, the grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense. The second firearm specification is a 3-year firearm specification pursuant to 2941.145A. The grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense. The third firearm specification is a 5-year firearm specification, drive-by shooting, pursuant to 2941.146A. The grand jurors further find and specify that the offender committed the violation of section 2923.161.
This is where the courtroom energy shifts. Aggravated murder, a minor victim, and multiple firearm specifications, including a drive-by allegation. Each specification adds mandatory prison time if convicted. This isn't just one charge, it's layers of exposure stacking up fast. Is this justice being thorough or overwhelming?
The revised code, or the felony that includes as an essential element purposefully or knowingly causing or attempting to cause the death or physical harm to another, and that the offense was committed by discharging a firearm from a motor vehicle other than a manufactured home. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. This offense is contrary to the form of the statute in such case made and provided, and against the peace and dignity of the state of Ohio. Okay, that's all count 1. There are 10 additional counts. Would you like me to keep reading? No? So you waive the reading of the remainder of the indictment in open court?
Yes.
Okay, sir. Do you wish to enter a not guilty plea?
Yes.
Okay, I accept your not guilty plea because
So that's not even all of it. He didn't want her to continue to read it. That's enough. I'm sure that's enough. Who knows what else is going on in this indictment? Because again, a $5 million bond. Well, let's see what she's about to get, the bond she's about to give him. I'm assuming, again, the same thing, $5 million. Then we certainly know that they're all connected, but they're all connected. But he said, that's enough, Your Honor. Stop it right there. Don't read any more of these charges because it gets deeper than this, apparently.
You don't have counsel with you right now. I am going to assign counsel to represent you to make sure that you're represented through all the proceedings in this matter, okay? If you choose to hire or retain a lawyer going forward, it's an easy fix. They can file a notice of appearance, okay? All right. Mr. George, the court appoints Attorney Thomas E. Shaughnessy and Attorney David Grant to represent you in this case because of the nature of the indictment. The court will appoint 2 attorneys to represent you, okay? Your bond is set at $5 million. That's a cash surety property bond. You're to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John.
To assign them 2 more attorneys, like she assigned the other individual, the other young man, 2 attorneys. Because the nature of the case, the nature of the indictment is that serious that you're going to need 2 attorneys. So everyone is about to get 2 attorneys. So they are indeed connected as suspected. Both got $5 million bonds. I'm sure the third individual that was there is about to suffer the same fate. All young individuals and she said, no contact or what have you with the surviving victims. So there, again, it is more than just this. It is more than what we've heard so far. He stopped her from continuing on with the reading of the indictment. So who knows what else lies in there. But clearly more people are involved, more victims. And it makes sense just based on the $5 million bond. I couldn't get over that. Whoa. Knowing what I know about the system. Well, I was about to say I don't know where these dudes are at, but in Ohio, we already know Ohio. They are in Ohio. And she didn't hit them with a $5 million bond. And they have surviving victims. Allegedly.
Satula. The first pretrial is on July 11th at 9 a.m. Okay?
Co-defendant B, Matza Andrews.
Certainly it's going to be the same thing here, this individual here. He's probably not going to, the video's about to end, so he's probably not going to agree to have the indictment read out in court. He's going to bust him upside the head with a $5 million bond.
How are you this morning?
Then he's done.
Okay. I need you to speak up just a little bit louder, all right?
Now notice that the judge didn't say good luck to them, good luck, young man, even if they're coming back in that courtroom, which they may not be, particularly for a pre-trial, certainly won't be there for a trial. She's there arraigning them. They'll have a different judge doing the trial for the most part. But normally they say good luck, even if you're in there, if you're a serial killer. But, these individuals may indeed be cooked. These are some very serious charges, some very young individuals and some very serious cash that the system is asking for in order for them to obtain their freedom.
Do you have an attorney, sir? No. Do you have the money to hire one? Okay. The court will appoint 2 attorneys to represent you in this case because of the nature of the indictment. Sir, have you received a copy of the indictment?
Yes.
When did you receive it?
2 days ago.
2 days ago, so it's been longer than 24 hours?
Yes.
Do you understand the indictment?
Yes.
So you understand the charges against you. Do you wish to waive the 24-hour notice? So you're allowed 24 hours before you have to come and stand before the court and enter a plea. You've had it longer than 24 hours, correct? So you're okay with waiving that 24-hour notice?
Yes.
Okay. Do you wish to waive give up the right to have your indictment read to you in open court? Okay, do you want me to read you the entire indictment right now in open court? No? Okay, so you want to waive that? Okay. Do you wish to enter a not guilty plea today? Okay, I accept your not guilty plea. The court will appoint attorneys James McDonnell and John DeCaris to represent you in this case. Your bond is set at $5 million. That's a cash surety property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. The first pretrial will be on July 11th at 9 a.m. Okay? All right, that's it.
Okay, that's it, she said. Like I said, and it is a different judge. She just said your case will be assigned to judge such and such. So she's not going to see these individuals again. She didn't wish them no good. Good luck to you, young man. They normally say that sort of stuff. I don't know why I'm stuck on that anyway. It's more about these victims involved in this case. They're going to need more than good luck anyway. If the allegations are true, a 13-year-old, as we heard, or someone under 13, so I don't know the age of this young individual, this child that was deleted, unalived, killed with a weapon, with a gun. Was child 10, 9, 11? Couldn't have been a gang member, out there on the street at 13. Nothing justifies this. So, and then a host of weapons charges, apparently some attempts, a drive-by, all sorts of stuff. Talking about surviving victims, so you must have charges against the surviving victims too. If she's referring to them as victims, means that they believe that you victimized them. They just didn't die. So you did something, assaulted them or whatever in some sort of way. So you have a multitude of charges clearly illustrated by the $5 million bond. What are the odds that these individuals will be able to bond out? I don't know, but let me know what you think in the comments. She just stuck it to them. They're young. But, the individual who lost his life was very young as well. So, a lot of people are not going to have sympathy on them based on their age. You're going to say that they know right from wrong. I don't know. What do you think? It's a tough situation to be in, that's for sure. Got his family and father putting up the house to try to save his life. Nobody wins in this situation, people. No one ever wins in these sort of situations, because here you have someone that's lost their life, and then you have surviving victims who are perhaps traumatized for the rest of their life. And then these three individuals are certainly in danger of losing their entire lives. With that sort of bond, with these sort of charges, aggravated murder, a host of other charges, drive-bys, attempts, surviving victims, everyone's life ruined. One bad decision, one bad night. We have to be smarter and do better. Stay safe and stay free, people.